Hey, federal employees, after more than 20,000 hours in these cases, here's the single number one biggest legal mistake I see federal employees making. Are you ready for it? The biggest mistake, I think, is them trying to handle a disciplinary notice on their own, especially when they have a good case. Agencies have lawyers and playbooks. When you go it alone, they often don't take you seriously. They're going to outwit you. And also, here's the paradox. The stronger your case is, the more you need an attorney to present it strategically. Watch to the end. I'm going to give you a playlist we use to flip cases before they ever reach the Merit Systems Protection Board. And I'm happy to give this away because I still think you need us. If you just opened a proposal to suspend or remove you, that punch in the gut feeling is normal. Breathe. You have rights to very short deadlines. Don't fire off a defensive email. Don't explain yourself in a hallway conversation. Get advice. We do free consultations and we split the risk with our clients if we think we can help you. If we don't believe we can move the needle, we'll tell you straight. If we do, we go to work. Your career is worth protecting. And again, I'm so confident that you need an attorney, even if you are an attorney, because they say an attorney who represents themselves as a fool. But I think everybody needs an attorney if they've got a good case. I'm going to even give you the checklist of things we look for. So you can try to run it on your own if you want. But the stronger their case, I would highly not recommend it. It's not just about coming up with an argument. It's about a process. You probably need an attorney. Anyway, here's the checklist. 1, due process. Did the agency give you the evidence file, real notice of the charges, and a meaningful opportunity to respond? Any harmful procedural error can be outcome determinative. 2, the proof. What's the actual evidence and who says what? We test credibility, inconsistencies, hearsay stacking, computer logs, metadata, chain of custody for tests, whether statements were taken with proper guarantees or Calkine's warnings, what that matters, and then we balance them under the legal system of figuring out credibility. 3, comparators in the table of penalties. How were similarly situated employees treated? If others got coaching or short suspension and you're staring at removal, that's disparity becomes leverage under a Douglas factor. 4, nexus and mission impact. Can the agency show a real connection to the efficiency of the service? Not just bad optics. Publicity, safety, trust, and job duties all matter. 5, the Douglas factors, your entire story length of service, past discipline or the lack of it. Performance record and awards, potential for rehabilitation, consistency with agency practice, notoriety, alternatives to removal. We don't let the deciding official recite Douglas. We actually try to get them to weigh Douglas. 6, statutory defenses. Is there whistleblower retaliation, EEO discrimination or reprisal, or denial of reasonable accommodations? Even when the action isn't purely about the issue, these facts can change outcomes and settlement posture. 7, process integrity. Ex parte contact with the deciding official, missing witnesses, late-breaking evidence you didn't get to rebut, union representation issues in investigatory interviews. These are all red flags. 8, performance cases. On PIPs, we check whether the standards were clear, set a firm benchmark, the opportunity to improve was real, and assistance was meaningful. For adverse actions, we force the agency to meet the correct burden of proof. 9, mitigation and solutions. Sometimes victory is a withdrawal. Sometimes it is reduced charge, a measured suspension, a clean record clause, training instead of removal, tailored last chance agreement that protects your future. 10, settlement leverage. We map the agency's risks and we put them in front of the right person, the right way, at the right time, before MSPB if we can, and at the MSPB if we must. If you've got a notice sitting in your inbox, don't go quiet and don't go solo. Depending on how far you in your career, your federal career is probably worth protecting, and you might want to talk to an attorney who lives this work. If you want to take a look, reach out. We have a free consult. We share the risk if we enter into an agreement with you. I'm Shaun, a federal employee attorney at Southworth PC. Please follow us for practical, plain English tips on protecting your federal career. Share with a colleague who needs to hear this today. I'm happy to get this information out there. Some people can't afford attorneys, but your career is worth protecting. So again, the biggest mistake I see is people who have a career that matters and they try to go the disciplinary process alone, especially if you're farther in your career. Even the smallest disciplinary matters, I think you should start with representation, but it can vary based on the case. That's why we have free consults. Feel free to reach out. Thank you everybody for your support. Please share this so people who have to go it alone, they have a checklist of the top things they should be thinking about. Thank you and have a great day.